Chris.
In the back door.
Chris, close that door.
Good morning. Good morning. How's it going so far, okay? Great. Unit 3? Okay. If we do this right, we're going to introduce ourselves, and we're going to ask you to introduce yourselves and your teachers. And then we'll read you the question, unless you need to know right now which one we're going to do. We want the suspense a little long. I'm Peter Gutt, former teacher.
Hi, I'm Anna. I'm a We the People alumna and current law student.
I'm Michael Tift. I am a social studies teacher in Brookfield. I attended years ago.
Good morning, judges. My name is Anthony Campo, and we represent East Hampton High School.
I'm Morgan Weinhoven, and we're all juniors.
I'm Aiden Favorite, and these are our lovely teachers, Ms. Kelly Brown and Ms. Taylor Diamond.
Terrific. Okay, so how about you pull out your notes for question 3. And while you're getting them out, I'll begin reading. That you know the question pretty well by now. We'll hear it out one more time. In the case of Brown versus Board of Education and Dobbs v. Jackson Women's Health Organization, was the Supreme Court justified in overturning longstanding precedents given the doctrine of stare decisis? Evaluate the court's reasoning in both cases and how it aligns with or deviates from this principle. Under what circumstances, if any, should the process of overruling longstanding precedents be addressed through constitutional amendments, new legislation, or a combination of both? Recently, many proposals have been made to modify the Supreme Court's structure or procedures, such as imposing term limits or increasing its size. Do you agree with these proposals, or do you favor leaving the court in its current form? Explain. Whenever you're ready, you can begin.
The legal practice of stare decisis originates in Blackstone's English common law and has played a key role in the American legal system. The doctrine stresses compliance with precedent unless a specific reason exists to overturn it, creating judicial predictability, consistency, and stability. Accordingly, the Supreme Court follows tests and self-imposed rules when disregarding stare decisis. The current court has overturned a number of precedents in cases like Loper Bright Enterprises v. Raimondo and Dobbs v. Jackson, with sweeping ramifications for the nation.
Brown v. Board was the culmination of a long series of precedents challenging Plessy v. Ferguson, including Sweppy, Painter, and Mendez v. Westminster. Brown was unanimously held, expanded rights, and was progressive in doing so, despite not directly overturning Plessy, but was criticized for using social science research and overturning laws created by elected legislatures with reserved powers to oversee education. Both Brown and Dobbs have faced significant opposition in the form of outright defiance and state police powers.
Dobbs, whose Justice Alito's standard established in Janus v. AFS-CME to overturn the holdings in Roe v. Wade and Planned Parenthood v. Casey on issues of quality, workability, consistency, subsequent development, and reliance on the decision. The majority in Roe and Casey held that abortion was a right protected by a number of privacy rights in the First, Fourth, Fifth, and Ninth Amendments, and the Due Process Clause of the 14th Amendment. Using the Glucksberg test, the court re-examined the right to abortion, holding that it did not reach the status of a fundamental right, instead applying rational basis scrutiny.
Although disregarding stare decisis can be destabilizing, Justice Thomas rationalizes the current court's frequent overturning of precedent through the metaphor of Supreme Court cases as cars on a train, believing that the court should ensure that the train's tracks follow the Constitution instead of a blind allegiance to precedent. The current court's Article 6, Section 2, derived implied powers of judicial review, makes overturning precedent through legislation hard as it precludes legislation contrary to court verdicts. Article 5's amendment process is effective but deliberately slow, and due to polarization, achieving the required 2/3 majority would prove nearly impossible.
In response to polarization and controversial holdings like Dobbs and Students FFA v. Harvard, President Biden created a Supreme Court Review Commission to help review the history of the court reform and potential changes to the court. The report discussed altering the size and composition of the court attempted by FDR during the New Deal, amending the tenure of justices, internal reforms, and jurisdiction stripping, a power given in Article 3, Section 2, Clause 2, which can preclude federal courts from ruling on military habeas corpus cases as seen in Boumediene v. Bush. The power is limited and dangerous, as without court oversight, few checks will remain.
In Federalist 78, Alexander Hamilton defended the life tenure of justices as helping to remove judges from politics, adding that the judiciary was the least dangerous of the branches as it lacked an enforcement mechanism in Article 3. Impeachment of a Supreme Court justice is possible under Article 3, Section 1, but has only happened once. Constitutional scholar Akhil Amar argued that term limits for the court could be created without an amendment and could be coupled with an expansion of the court to create a system in which each judges would hold a staggered terms of service, affording each president 2 appointments per term. Justices out of active service would remain for life, performing additional duties and advising the court.
Considering the overturning of long-standing precedents in cases like Dobbs, Loper Bright, and Students for Fair Admissions v. Harvard, it may be necessary to reassess the way the court establishes fundamental rights and protects super precedents. And rapidly changing a dynamic society, relying on historical tradition can be flawed and leaves no room for new societal developments. And perhaps the legislature should supersede the court in protecting these liberties. Thank you. We're ready for your questions.
Thank you. What would the new method for determining how fundamental a right is be in your estimation?
Well, I think right now with using the Glucksberg test established in Glucksberg v. Washington, the idea of historical tradition and kind of measuring what that would be is pretty difficult. So I think that you would at least want to apply historical tradition in a consistent way. Where we see in Dobbs v. Jackson and the way that they applied historical tradition, we see how it differs in the Bruin case. And specifically in Dobbs, using historical tradition, looking back at Roe v. Wade and how abortion was illegal at the time of the 14th Amendment that they said it was protected under. So when we look at Bruin, we look at how they used historical tradition and how people, when the Second Amendment was a thing and it gave people the right to firearms, that was always kind of a right that they wanted protected falling under historical tradition. And they kind of talked about how the absence of laws restricting restricting gun rights meant that it was a historical tradition, whereas in Dobbs, they talked about how there's an absence of rights in an absence of laws restricting abortions meant that it was not historical tradition because the 14th Amendment was around when abortion was still illegal.
I was very impressed by your discussion of the potential right to privacy and the penumbras of the amendments that it exists in. I'd love for you to tell me more about what you know about the right to privacy and whether or not you think that it is in fact a constitutionally protected right and why.
So are you speaking more specifically on abortion and Dobbs v. Jackson?
You can interpret it however you like.
Okay, well with abortion, and they were talking about, there's a story that kind of follows those rights and the privacy rights, starting with Griswold v. Connecticut and applying the First, Fourth, Fifth, and Ninth Amendments as the privacy rights to the right to contraception, and they ended up using the same precedent in Roe v. Wade, and then in Planned Parenthood v. Casey, they applied the 14th Amendment and the Equal Protections Clause to abortion specifically, then following with Lawrence v. Texas and protecting gay intimacy, as well as then Overturning v. Hodges protecting gay marriage under the same privacy rights and the 14th Amendment.
I think when we look to these privacy rights and whether they could possibly be in danger in the future, in the dissent of Dobbs v. Jackson, the Sotomayor-Kagan dissent, they talk about how since the rights to privacy, like when Lawrence v. Texas and Obergefell v. Hodges protecting gay intimacy and gay marriage respectively, they could be in danger since they can overrule on these precedents, as well as Justice Thomas said if they get a case similar to these protective rights, they have a duty to review them.
Actually, can I sneak in one very quick follow-up? I really like the mention to Lawrence. Are you guys aware that Lawrence also overruled a Supreme Court case in the past? Okay, I'm going to skip it. That was an unfair question. Moving on.
There have been a whole host of interesting Supreme Court rulings in the past that have done a number on precedent. Are there any contemporary issues that you can think of that require immediate changes to existing legal decisions by the court?
I think because of the overturning of Roe v. Wade and Planned Parenthood v. Casey, it would be very important to attempt at least to pass an amendment to protect the right to contraception as well as the right to gay intimacy and gay marriage because they were protected under the same privacy rights and the 14th Amendment Equal Protections Clause, and that was proved to be invalid in Roe v. Wade and Planned Parenthood v. Casey.
In addition to what my colleague said about the actual amendment process, in Article 5, it talks about how you need a 2/3 majority of the state legislators to even propose an amendment. And as actually the speaker was saying in the House, with how much tension there is in America and government and therefore Congress, it will be very hard to actually get an amendment passed.
In the majority in Dobbs, they argued that the Constitution was neutral on the issue of abortion and the issue of privacy in this way. And so they gave that decision up to the states because they couldn't decide on the morality of it, as that's not their job. It's their job to look at the Constitution. And so if that same issue would apply to other cases, even cases that would protect contraceptives, then maybe there's an issue, like my colleagues have said, that needs an amendment, because if the Constitution is neutral on this, then there might be an issue that needs to be fixed to make the Constitution not neutral.
Whether you agree with it or not, pick one of the reforms proposed to the Supreme Court and explain how you think it would affect the way they interpret the Constitution.
Well, one of the reforms that we talked about was an expansion of the court, and from 9 justices to 13 justices, because there are 13 circuit courts. Yes, there are 13 circuit courts, and there are only 9 justices. So it would be more effective, I think, for representation at least, to have 13 justices as well.
Originally, there were the same number of judges as circuit courts, so it's not unreasonable to want that to go further. And as far as how that would influence their way they look at the Constitution, a larger pool of judges means more opinions about the Constitution. So that means more discussion about different things and more views on how it should work. So you're going to get more diversity in people's ideas of the Constitution.
And as far as